Now you can ask. Elizabeth, can you see me?
Yes, I can. Can you see me?
Yeah. Hello.
You can hear me okay?
Yes.
Great.
We are not. Wait a minute. Yeah. So we're still in the practice session.
Yes.
So we are not.
Presenters' remarks. So if you have those questions to us, we can take those at the end. I'm going to spend the next 15 or 20 minutes talking about three large areas. I'm going to start off by giving a brief introduction to business and human rights as a field and some of the main developments in that field. I'll say a few words after that about extractive industries in particular, since the Ogoniland case, obviously extractive industries are the most relevant. And then I will finish my remarks talking a bit about access to remedy for victims of corporate-related human rights violations. So I'm now going to hopefully share my slides, and hopefully people can see that. So I'm going to start with some remarks on business and human rights as a field. This is an area that basically didn't exist 15 or 20 years ago as a field of practice and a field of scholarship. And there have been some important developments in this area in the last 12 years or so. And I'm going to just briefly go through those right now. There's a long history within the UN of trying to deal with the question of corporate responsibility for human rights. And in between 2005 and 2011, there was a mandate within the UN, the appointment of John Ruggie as the UN Special Representative for Business and Human Rights. And he was coming into a session of substantial polarization around this question of corporate responsibility for human rights. And in the first 3 years of his mandate, he created a framework on business and human rights called Protect, Respect, and Remedy. And that framework is split into 3 pillars of equal importance: state duty to protect, and that means the state's obligation to protect everybody within its territory from violations of their human rights, including by corporations. Corporate responsibility to respect, and that means that corporations should do no harm, and they should, if they do commit violations of human rights, they should address their adverse impacts. And access to remedy, which is what happens if you are the victim of a human rights violation by a corporation. 3 years later, John Ruggie and his team published the UN Guiding Principles on Business and Human Rights, which put some flesh on the bones of that framework. And those guiding principles were endorsed unanimously by the UN Human Rights Council. A couple of key takeaways, because this is a major development within the field of business and human rights. Key takeaways on the guiding principles: they do not create any new international law obligations. They were meant to clarify existing standards and practices. They're based, as I say, on 3 pillars of equal importance. They take into account all internationally recognized human rights, and that at a minimum means that corporations must respect all of the human rights within the International Bill of Human Rights, as well as the ILO core conventions. Another key takeaway is that the focus is on human rights risks and not risks to companies, financial risks, for example. And this is an important turning point, particularly for companies, to understand that when we talk about risk to human rights, we're talking about risks to human beings. The responsibility, corporate responsibility to respect, as I said, means in its simplest form, do not harm human rights. And if you do, you must address your adverse impacts. But just as importantly, the responsibility to respect exists independently of state duty to protect. And that means that according to the guiding principles, companies cannot simply say, we are operating in a place where human rights are not well protected, therefore it's not our problem. That's not acceptable according to the guiding principles. Another key point is that the guiding principles apply to companies' own operations and their business relations. And that means major suppliers, private security companies that they contract, militaries that they work with, joint venture partners, governments that they work with. And so this is an important point. And finally, human rights due diligence is a key concept that emerged with the guiding principles and with the framework. And that is that as part of their corporate responsibility to respect, companies must identify, prevent, mitigate, and account for human rights impacts. And I'll come back to that a little bit later. The guiding principles are, they were put forward as soft law, but I'll come back to that point as well. A couple of key challenges and problems or gray areas after the endorsement of the guiding principles. Extraterritorial jurisdiction. Charity will say some more about this in her remarks, but extraterritorial jurisdiction refers to the legal ability of a government to exert its jurisdiction over companies domiciled in its own country when they've committed or contributed to human rights abuses abroad. And a key criticism of the guiding principles has been that they didn't go far enough in this area of extraterritorial obligations of states. What they say about extraterritorial obligations is that at present, states are not generally required under international human rights law to regulate the extraterritorial activities of businesses domiciled in their territory, nor are they generally prohibited from doing so. And in fact, a number of legal scholars have disputed that point and have asserted that states do have extraterritorial obligations under international human rights law to protect people's human rights from company abuse. The bottom line is that companies are not currently regulated in any meaningful way for extraterritorial human rights violations, and this is a key challenge in the wake of the guiding principles. A second area of criticism about the guiding principles was their non-binding nature. However, pieces of the guiding principles are being incorporated into laws and other guidance, and I'll come back to that if I have time. And a third point of contention or challenge with the guiding principles is the weakness of the third pillar, access to remedy. And so I'll come back to that in a moment. I want to say a few words about the extractive sector in broad brushstrokes. Extractive industries have a particularly heavy footprint on people and environment, perhaps for obvious reasons. The Special Representative on Business and Human Rights, John Ruggie, himself and his team found in their research that extractive industries are associated with the largest percentage of human rights violations of all sectors. James Anaya, who was the previous Special Rapporteur on the rights of indigenous peoples, said a few years ago that natural resource extraction on or near the territories of indigenous peoples constitutes one of the most important sources of human rights abuses of indigenous peoples worldwide. And I'm sure many of you on the call are familiar with the human rights that are often negatively affected by extractive industries. And when I say extractive industries, I'm talking mainly about oil, gas, and mining. Right to security of person, just and favorable work conditions, adequate standard of living, the right to cultural life and freedom of religion, the right to clean environment and clean water, freedom of movement, self-determination, which is the right of peoples to use their natural resources as they see fit. And within this heavy footprint generally on environment and society, there's a disproportionate negative impact on indigenous peoples. Their traditional lifestyle and culture are especially affected, negatively affected, when mines or oil extraction contaminate the waterways and the land that indigenous communities rely on for sustenance, livelihood, cultural purposes. And I also want to highlight that there's a significant negative impact of extractive industries on Indigenous women in particular. We see many cases of violence against women, exclusion from jobs and negotiations around extraction of resources, cash influx that has a negative effect on social roles, etc. With extractive industries as well, we often see major failures by both states and multinational corporations to respect human rights and environment, and failure even to consult Indigenous peoples about extracting natural resources from their land. And I wanted in that context to toss up one definition of free, prior, and informed consent, because it's a key issue when we come to extractive industries and human rights. Free, prior, and informed consent is consent that's given freely prior to any decision being made about land or resources to be exploited. And this matters greatly to the right to self-determination that I mentioned before. And extractive industry projects don't take place in a vacuum. They take place in areas where there generally are people already. And one of the key negative impacts of extractive industries has been on this right to self-determination due to a failure to consult fully and in a anticipatory way with people whose lives will be affected by extractive industries. I want to finish just with some remarks on access to remedy, weaknesses, and some potential avenues forward. So after the endorsement of the guiding principles in 2011, we've had now 7 years to look back at what has developed since then. And the lines have certainly become clearer around the weaknesses in the area of business and human rights. And as I mentioned at the outset, a key weakness is this third pillar: access to remedy, access to justice for victims of corporate-related human rights abuses. The right to remedy is enshrined in international human rights law. We see it reflected in the Universal Declaration of Human Rights. We see it reflected in the International Covenant for Civil and Political Rights. And when I say remedy, I mean it in a very broad sense. Remedy can include a formal apology. It can include rehabilitation or reparations for harms done, restitution, compensation, whether that's financial or other. It can include government fines for corporate wrongdoing. It can include injunctive relief. Any number of things fall under remedy. And as the third pillar of the guiding principles notes, we need both judicial and non-judicial remedies. Any one of them is not going to be sufficient. And so here's just a partial list of the types of mechanisms that might be used for access to remedy. And some of these will be touched on later in the webinar. Judicial mechanisms generally refers to access to the courts, the ability to bring litigation against somebody. Non-judicial mechanisms are maybe a broader category of mechanisms, and I've put some examples up here. The OECD national contact points. These are part of the OECD guidelines for multinational enterprises, and every state that is a member of the OECD is required to establish a national contact point, which is a state-based non-judicial mechanism and which has been used in cases where multinational corporations have breached the OECD guidelines. We see ombudspersons appointed by governments. There are national human rights institutions, mediation and alternative dispute resolution, company-level grievance mechanisms, and just as importantly, and perhaps more newly emerging, community-driven operational grievance mechanisms. So this is just a selection of the range of access to remedy mechanisms that exist. The bottom line is that there is no overarching world court to which multinationals can be brought and to which we can bring them to hold them accountable on human rights violations. So where do people turn? Well, legal options include the domestic legal system of the host country, that is the country in which the company is operating and has had its impact. There's also the domestic legal system of the home country in which the company is legally domiciled or headquartered. Host country judicial solutions are often inexistent, partial, fraught, very difficult to access. And that's partly because host governments, particularly in connection with extractive ventures, may have a very close relationship with the multinational corporation implicated. And I know that there's obviously been work or research on that in the case of Shell and the Ogoniland case. Host country judicial solutions are also particularly problematic because in some countries the judiciary is not independent. In some countries, human rights defenders who would try to blow the whistle on corporate abuses are explicitly targeted by either the government or the companies or both. Turning to home country judicial solutions, this is something that I think Charity will be talking more about. There's not a lot of examples of successful cases, but that may be changing. And while there's been a closing off of US courts for extraterritorial cases involving multinationals, multinational corporations, in Europe and Canada, some legal scholars think that things are pointing in a different direction, and there may be some way to find access to remedy in those areas. The upshot is it's very difficult for victims to get access to a legal remedy, and hence we have significant criticism of the third pillar. There is a broad set of actors and tools beyond the courts that we can think about when we talk about seeking accountability. There are NGO campaigns, investigative journalism, responsible investors, and all of these may provide some way to get towards access to remedy. And I would just recall a point I made earlier, which is that judicial and non-judicial mechanisms both need to be robust. We can't have one without the other. But at the end of the day, legal solutions are key. They're really crucial because in practice, we have not been able to rely on the goodwill of companies, for example, to clean up oil spills. So we do need legislative solutions. And I just wanted to end on that note by pointing to a couple of emerging legislative initiatives in a number of countries and regions. In the last 10 years or so, we've had the emergence of mandatory human rights reporting for corporations. And there are a couple of examples up on the screen, which I don't have time to go into, but if people have questions, we can talk about later. And more recently, emerging laws that mandate human rights due diligence for corporations. And here's an example of what I was saying earlier. The concept of human rights due diligence comes from the UN guiding principles and is being incorporated into emerging laws, very interestingly. So we have just only the first of these three has actually been passed. The French duty of vigilance law was passed in 2017, mandating French multinational corporations to create a duty of vigilance, to create a vigilance plan based on the concept of human rights due diligence. So we may be seeing some change in terms of increased accountability or increased ability to hold companies liable. These need to be tested. These are just emerging now. And so I don't think I'm going to end on a very optimistic note. I will just reiterate that it is very difficult when we're talking about multinational corporations and extractive industries to get access to remedy. So that is all for my comments. And now I'd like to turn it over to Charity. Thank you.
Thank you very much, Elizabeth, for your presentation and explanation about the situation from the legal perspective and an academic perspective, or what it means, human rights and business. For instance, you were quoting United Nations guiding principles and some examples of legislative initiatives in other countries. As we all know, this is the challenge actually lies on the access to remedy. And now I will give the floor to Charles Wiwa and then to Jati Ryerson to explain a real life situation, how you make to how you implement access to remedy on real life situation in a country. Charity explain the situation in the US, how actually her organization is trying to do so in the US, and of course, what it means from the ground to live this, to pass through this experience in a real life situation of in a place which is actually polluted and contaminated by an oil company located in Ogoniland in Nigeria. So after this general explanation, I would like to remember that you can ask questions there. In the bottom line, you have an option called chat. There you can write your questions if you wish to address one of the panelists. And if you want also to speak eventually, if you want to share your experience, I can also give you the floor if you want to address the participants. Just to remember that all the session is recorded. Once the session finished, you will receive a link to watch the entire session again, of course, including the slides, and also to remember that right now the session is broadcasted through Facebook. So thank you very much. Now I give the floor to Charles Weaver.
Thank you, America. My name is Charles Weaver, an Ogoni activist. I've been living in Chicago for the past 22 years. I'm actually going to be 22 years in September. I fled Nigeria to neighboring the Republic of Benin in 1996, following the executions of Ogoni activists. First of all, I'd like to give you a little background about Share's activities in Ogoniland and the Niger Delta of Nigeria. Oil was first extracted in Nigeria in 1957 at Oloibiri, which is actually very close to Ogoni. It's also in the Niger Delta region of Nigeria. And at that time, it was the British colonial rule. They ushered in Shell. They came in freely. And to this day, there's just no record of any of our forefathers signing any agreement for the way they will conduct business with our people. So they came in to exploit. So they started exploring oil from 1958 in Ogoni, in Kedere, which Shell chose to call Bomo oil fields. They started extracting oil. We didn't have any of our people working with them. And for the period of 30 years, we started experiencing that our environment was being degraded. We found out that our crops were not growing. Our fishermen were no longer yielding any profits from their business, the fishery business in Nigeria. And Ken Sarawiwa at that time formed MOSOP in 1990 to pursue these problems that the people of Ogoni faced. MOSOP means Movement for the Survival of the Ogoni People. It was a nonviolent struggle, which still exists to this day. So we started writing to the government and to Shell to say, this company, they're committing all kinds of atrocities. Our environment are devastated, and we can't even breathe fresh air, and they're not doing anything. There's just no remedy, because when there's oil spill, there are old gas pipelines that are, breaking up. They're not coming back to fix it. They're not doing anything. And for one full year, the government did not respond. The dictator at that time was Babangida, Major General Babangida. He did not respond. So what we did as a people was to come together under MOSOP to advocate, non-violently, started protesting to say, we want this company out of our land. We want them to take some responsibility for all the devastation in the area. But they wouldn't. What they did was to invite the military to protect them while they're exploring oil in Ogoniland. So you see shell workers in the oil fields, and you see the Nigeria's military, like the police, the army, guarding them, which shows clearly that the oil they're getting from the Ogoni area is stolen, because if they're not stealing it, they will have a relationship with the Ogoni people. So when that happened, the Ogoni people continued the struggle and pressed it, but because we were able to make all these things going on international, we were able to make it, known to the outside world. What Shell did was to, crack down on activists, and the end result was killing some Ogoni chiefs, and blaming that on some activists and putting them in jail without trial for a long time, and trying the Ogoni activists, the Ogoni leaders, in a military tribunal, which led to the hanging of the Ogoni 9 after the 4 of Ogoni chiefs were killed. And after that happened, there was a serious presence of army, of military in Ogoniland. And even though the Ogoni people succeeded in pushing that share, because since then they stopped, serious business, serious oil exploration in the Ogoni area. A lot of over 3,000 activists were pushed, underground, and many fled. Many are scattered around the world today. And it's sad that Nigeria as a country is within the pockets of a company called Shell, because we've seen that Shell has influenced elections in Nigeria, have influenced those who become leaders in that country. So it's been so difficult getting Shell to court, getting them to take responsibility of crimes in the area. All of these ties they use in prospecting for oil in Nigeria, they cannot use that because the flare gas very close to human proximity. And in Ogoni, we only have like 400 square miles that is inhabited by over 500,000 people, which means 1,250 people living per square mile. The average of Nigeria, when compared, is just 300 per square mile. So that really causes a problem, because so many people depend on that land for their survival. They depend on the environment. They depend on, just their farms and the rivers around just to sustain their life. And all this is taken away by this oil company. And none of the noises we made, deter them from continuing to explore oil in a very crude way like they did in Ogoniland. So after they killed the activists, a lot of the 9 leaders, a lot of activists went underground. They believed that would have given them a leeway, but sadly for them, the activists that fled Nigeria went overseas. Some went to England, some came to America, some are in Europe. They started speaking up, went to Congress. Some of us went to Congressional Human Rights Caucus here and spoke, and they started speaking to Nigeria on our behalf and to draw their attention to what was going on. And like we demanded in the Ogoni Bill of Rights, that it is important that Shell and the international community gets back to Ogoni and conduct environmental impact assessment studies and social impact assessment studies on the people. So the United Nations, did that through UNEP, United Nations Environmental Program, which found that the level of contamination is so high. It's 900 times above what is acceptable anywhere. And that's how we are seeing a little response from Shell sending money to Nigerian government to do a remediation program, which they've not started because people still drink from oil wells in Ogoniland. And up to this time, there are no access to health services, there are no good schools, there are no good roads. And these are simple things that the Ogoni Bill of Rights has been asking for, just for the basic things of life. We wanted to use a portion of the Ogoni resources to develop Ogoni. They wouldn't let that happen because they want to impose everything on the people. They want to just exterminate Ogoni people from the surface of the earth. But thank God there are people, around the world, organizations around the world that the Ogoni people continue to work with, like Amnesty International, Greenpeace, Corporate Accountability Lab, Ankawa International, who are helping to still continue this. Presently, it appears as if something has been done, but I'd like to add very, very importantly that in Ogoni, nothing has changed. It's worse because Shell, they are bent on coming back for extraction, to extract more oil. We do not want that. What they have done is to talk to those in government to try to give concession to other companies who are under them so they can come back to Ogoni. What I see is that they're trying to cause more chaos in the area because presently, all activists in Ogoni have been cowed. Shell and other oil companies are giving money to militants in the area, militants in Niger Delta, to cause trouble and to invite them back to the area. Because the Geneva people of Ogoni do not want Shell back. They want to sit down with any company that would prosper for oil in Ogoniland to align, the methods of which they can explore for oil. At least they should explore for oil in Ogoni like they do it outside of Nigeria, like they do it. They don't like to do that because they want to sit down and continue to explore oil where they won't pay royalties, where they won't have any responsibility to the environment, where they won't employ the people. So those who can speak up in Ogoni are seriously under attack. Being cowed. The people that are working, people asking them to come in, and the government are not talking to the right people. So we can sit down and say, okay, there's an understanding. We have the Ogoni Bill of Rights. Let's see what they want to take out of that. Let's see out of the points we enumerated in the Ogoni Bill of Rights, where they want to start from. First of all, we want them to take some responsibility. First of all, they have to clean up. The UNEP report gives 25 to 30 years for cleanup, total cleanup of Ogoniland. They've not started, and yet they want to come back through the back doors. And the result of that, we have to be very careful, is that more people will die in Ogoni. They're going to cause more trouble because they're trying to push people out and just go there and explore oil recklessly. And that is not going to help anyone. So all the platforms around the world that have been helping Ogoni people, we'll still continue to work with you guys and see how we can do this. I personally, when I got to the United States, I felt so bad. I felt like I was being forced out of Ogoni. So the first thing I did was to take Nigeria to the Human Rights Commission, African Commission on Human Rights. And at that point, Nigeria refused to show up. And this case was, ruled against the country for violating my rights. Because initially, when I fled Nigeria, I had, suffered a lot of beatings, arrests, beatings, and jailed in a military camp for 2 weeks. And when I was brought to a civil court, I escaped from that time. I went to Republic of Benin, where the United States Department actually saw me and said they read about my case and they were willing to resettle me in America. But it's not enough because most of those who fled with me are still back there in different countries as refugees. They are not anywhere. They are afraid to go back to Ogoni because they cannot continue to take up this struggle back there in Ogoni. Most of them lost their homes, they lost their parents, they lost families, and they cannot go back there. They're still scattered around the West African coast as refugees, and no one is even remembering them. So Ogoni people are still cowed. We still see the presence of Shell, even though they're not exploring anymore in Ogoni. They still send people, and they're buying guns for these militants to cow citizens in the country. And it's a problem. Although most of Ogoni youths that came to the United States came together and dragged Shell to court, which led us on to the Cuba case, Cuba versus Shell, which got to the Supreme Court of America. It's not different in America. I'm not afraid to say it. It's not different in America. The system looks okay, but it's not okay to allow a corporation to dehumanize those from minority groups like Ogoni and allow them to operate there and not give them any punitive measures. What the Supreme Court said was that the crime was committed in Nigeria, and those that suffered the human rights abuses were Nigerian citizens, even though all of those in that cubus suit are Americans, were American citizens. But this is to give Shell that power to go out outside of America, outside of Europe, to go to third world countries, developing countries, and commit crimes and run back here. And I want to give credit to Ogoni people that we've continued under the nonviolent motive. We've not harmed anyone. No military person has died in the course of our struggle for over 30 years. No military person in Nigeria has been reported killed by our people. And I believe that the whole of Ogoni people deserve something like Nobel Peace Prize, for handling this situation so well. But I want to warn clearly that we are not afraid. We've lost the best in Ogoni, and we'll do everything possible to face any company that wants to come through the back door. We're not afraid. We'll continue the struggle, and we'll continue to speak out against this oil company that believes that because they have so much money than most countries like Nigeria, they have countries in their pockets, they control what laws, that are being carried out, like the land use decree, Decree 2 in Nigeria that's been enshrined into the constitution of the country. It's a military decree that gives everything that belongs to anyone's environment to the government. And any government that is not responsible to its people, any government that is within the pocket of the company loses claim to sovereignty. And I believe that that's what we have to look at, because Nigeria has dehumanized its citizens, Ogoni citizens, and other Niger Delta peoples. And that should not happen. If they allow this to happen and continue to happen, they're listening to oil companies, to the multinational oil companies, a foreign firm, and not listening to their own people, and they lose claim to that sovereignty. Thank you so much.
Thank you, Charles, for your really overwhelming explanation of on the situation on the ground right now in the Ogoniland. How actually, instead of pursuing peace, actually the system seems to be deploying more repression to, in particular, activists and human rights defenders on the ground. We understand what you are expressing to all of us here today regarding that you want to clean up the region and you want the human rights to be respected. That's why the Ankawa International Organization and institutions such as the Corporate Accountability Lab are trying to promote this case wherever is possible, mainly in Africa. So just to remember that you can always ask questions on the chat section, and after each presentation, we will try to respond to address the question. It seems to be a question for Charles. Yes. So Charles, please take note of that question, and I will send it to all of you just in case you are not receiving the question. And then you can reply after eventually Charity's presentation. So I would now give the floor to Charity, and at the end, all the questions will be responded. Thank you very much. Charity, you have the floor.
Hi, thank you, Amilcar, and thank you so much, Charles. That was really, that was extraordinary and very helpful. I'm just going to share my screen quickly. Okay, hopefully that worked. Let me, okay. This webinar I think is so unique in that we have an academic, an affected community member, and a practitioner coming together to talk about business and human rights broadly, but using this particular case study, I think sets us apart in a certain way. So the Ogoni case, as you just heard from Charles, is egregious. It's long-standing. It involves an extraordinarily diverse set of actors. And what is really striking about it is that it the Ogoni community has been extraordinarily active over the years. So they have pursued justice all over the world in many, many forums. And I think that has given them certain advantages, but it also provides us a great ability to look at how the global legal system is dealing with access to remedy. If the Ogoni community has fought this hard for access to remedy and hasn't achieved it, then what kind of commentary is that on the state of the global system right now and how it's dealing with victims of human rights abuses around the world? So I'm going to talk through some of the different strategies that members of the Ogoni community have employed, but I want you to hear this not just as a discussion of the Ogoni and their strategies, but also as a little bit of a tour of some of the different types of strategies and fora that are available to victims of transnational corporate abuse around the world. I just have a few slides, so I'll toggle back and forth between my face here. And as with the other presenters, please feel free to hang on to your questions, and at the end we will address all of them. So take note of them as I go through this. So before I talk about some of the specific strategies that the Ogoni have employed, I'd like to zoom out a little bit and talk about some of the common issues that face any victims or any litigants who are trying to pursue remedy currently. And this isn't necessarily a commentary on how well the system is working. I think some of these issues are just inherent to these types of crimes. So I think there's three things that as I go through these different strategies, I want folks to be listening for. One, who is the plaintiff? So in this case, when we're talking about the Ogoni community is not monolithic. There is a great diversity of perspectives within the Ogoni community on different issues. There's a number of different kingdoms that might represent different interests, that might have different types of effects. And I think that has, you'll see that as we go through, that different portions of the Ogoni community have pursued different strategies. And I think that's worth keeping an eye on, and particularly because when you have a corporate human rights abuse like this that is so large and affects thousands and thousands of people, how do you bring a claim that effectively can provide remedy for such a diverse group? And then, so the second piece there is, what are the harms? So are the harms that are addressed in each of these fora that we'll discuss, are those harms that could be remedied in this forum? Do all fora provide the same remedy to litigants, or are you going to be able to get some remedies in some forums and other remedies in another? You know, particularly for the Ogoni, as Charles just described, the types of harms at play here are pretty diverse. So there's definitely the harms that resulted from the oil spills. It's the lack of the ability to rely on the agricultural system because the food is contaminated, the fish is contaminated, so they can no longer eat as much fish. A lot of the fish have been driven out of the areas where the Ogoni used to fish. So access to food is affected. Health has been greatly affected in many ways, and I think the extent of the health crisis in the Ogonilands has not been studied thoroughly enough, and more information needs to be uncovered there. But there's also claims related to Shell's complicity in the violence against the Ogoni community, particularly in the 90s, that Charles just described, and caused many people to flee. Many protesters were killed, many were tortured, homes were burned, women were raped. There's an extraordinary range of types of harms that range from political violence and repression all the way to the day-to-day inability to earn a livelihood in the Ogonilands that has resulted from these crimes. And then the third thing that I hope folks will listen for is who is the defendant and how is the defendant fashioned in each of these cases? So is there only one party responsible? What's the corporate structure of the company? And I raise this because when we think of a company like Shell, we might think, oh, Shell is a company. But in fact, Shell is a complicated family of companies that includes joint ventures and shell companies, different types of operating and non-operating entities. This is pretty much always the case. So when you're going after companies for the human rights abuses that they commit in their transnational operations, you're almost always going to see a very complicated corporate structure, and that's going to give them a lot of defenses. It's going to make it a lot easier for them to shift responsibility from one entity to another. Maybe you can get jurisdiction over the parent company, but you can't get jurisdiction over the operating subsidiary, or vice versa in a particular forum. And so just by shifting responsibility between those entities, there's a great ability to avoid legal liability in many of these cases. So I'm going to talk through some of these different strategies that the Ogoni have employed, and actually Charles raised some of them already, and some of them also Dr. Umlas raised, so that will make my work a little easier here. And again, you know, I do hope that you can, without giving a lot of context on each of these, I know that we have a very diverse audience here. Some are attorneys, many of you are not attorneys, so I'm going to try to make this as accessible as possible, but, you know, again, please note your questions as I go. So as Charles mentioned a few minutes ago, the African Commission on Human and People's Rights, there was a complaint filed. Charles and others filed that complaint in 1996. So for folks that are not familiar with the African Commission and the African Court and the Inter-American Court of Human Rights, the European Court, there's a series of regional international human rights bodies that are tasked specifically with hearing human rights cases as human rights cases. So you'll hear as I go through this, often when we get into domestic courts, we aren't fashioning our claims as human rights cases. They're instead fashioned in other ways in some cases. So in these international human rights courts, they have, for example, the American Declaration for the Inter-American Court of Human Rights that enumerates the specific human rights that are covered by that court. And similarly, in the African Commission and the African Court, they have the African Charter that enumerates those different rights. And one thing that is interesting or important to know about these courts is that they don't just look at civil and political rights. I think in many cases, domestic legal systems, though not all, I think the US is kind of an extreme in this. There is more of an emphasis on civil and political rights and less of an emphasis on economic, social, and cultural rights. These courts certainly give an emphasis to economic, social, and cultural rights and the collective rights of communities in a way that they might be able to provide remedy for those types of harms in a way that a domestic court might have more trouble with, depending on the country, and there's a broad spectrum there. So this is a unique forum for that reason. So in 1996, this claim was brought alleging that the Nigerian government, in collaboration with its national oil company and Shell, which is a joint venture that has done this oil exploration in the Ogoniland, that they engaged in irresponsible oil development practices and polluted the Ogoni territory. Now, in addition to the spills, this complaint dealt also with the Nigerian government's sort of protection of Shell's economic interests through the type of political violence and repression that Charles described. So specifically destroying homes, burning crops, killing protesters, and exposing the Ogoni in general to a climate of terror in violation of 7 articles of the African Charter. So the Nigerian government, as Charles mentioned, failed to participate in this process, which is an indication of the level of enforcement that some of these bodies have. So while it was found that the government did violate all 7 of these rights that were alleged to be violated, there wasn't any ability, because of the lack of participation, to enforce the judgment against the Nigerian government. So while I think that these courts have, since that time, there have been significant evolutions in all of these bodies since that time, there is a real challenge of enforcement. There are a lot of really great judgments that come out of these courts, and many of these are ignored. So while I think that these are really important bodies for actually providing remedy to victims, they can be a little bit fraught. Dr. Umlas also mentioned the OECD guidelines for multinational enterprises and their complaint mechanism. The Ogoni have also brought 2 complaints under the OECD guidelines. These complaints, I won't go into them in great detail, but they were brought by Friends of the Earth and Amnesty International. One was brought in the United Kingdom and one was in the Netherlands. And the reason for that is that Shell is a Dutch and UK company. What's fascinating about these processes, the national contact points, which is where you would file such a complaint, they have a great amount of power in each of these complaints to make decisions on how the process goes. The experience for these 2 complaints that Amnesty and Friends of the Earth found was that the process for them was fruitless. So they were encouraging Shell and the communities to engage in dialogue, and they felt that Shell was not engaging in good faith, and the national contact points were not pushing them to do so. So some analysis of the OECD mechanism that I have read has been that the efficacy of such a mechanism really depends on the particular political will of the national contact point that's being used. So while I think that this did not end up being an effective strategy thus far for the Ogoni community, I won't say that it holds no potential it is right now limited, and I think that there isn't a lot of potential that has been realized through this mechanism, but as a non-judicial mechanism, it is something that is available to victims of human rights abuse. But now I'm going to shift over to domestic court strategies. So you'll see I have a list here on my slide, and I'm going to take my slide down in a second here, but you'll see I have a list. So the Ogoni have pursued legal action in 4 different countries in the world. So again, this is a very activist community who has really advocated on their own behalf in an extraordinary way. And so I think that, you know, we need to, as we look at this, just at every point, stop and say, wow, it's extraordinary that they were able to do this. So you'll see they brought cases in the United States, in the United Kingdom, in the Netherlands, and Nigeria. And one of the questions that popped up was on the Dutch and UK cases. And so I am going to talk about that a little bit. And if Charles wants to jump in more on that, he's welcome to. So I'm going to stop share here so you can see my face. So on these, each of these cases were very different. They were brought, you know, sometimes different plaintiffs, different claims, different defendants, which would be different members of the Shell corporate family. So I'm going to talk through those a little bit, but remember those 3 categories as I talk through it. I think it's helpful to think through the way that this operates. So first, I'm going to spend most of my time on the United States and the Alien Tort Statute. Now, you might say that's because I'm a U.S. attorney, and that probably has some impact, but in fact, it's because the Alien Tort Statute and what happened through the Ogoni cases in the United States have had a massive impact on the ability to litigate human rights cases in the US. And so by being such an advocate, such an activist community, they've actually influenced the legal several legal systems around the world. And I think the most significant one would be in the United States with the Alien Tort Statute. So a quick background on the Alien Tort Statute. This is a 1-sentence statute that gives an alien, which is to say a non-US citizen, the ability to sue in US court, in federal court, for a violation of the law of nations. So the law of nations has been interpreted to mean customary international law, but only a very specific group. So extrajudicial killings, torture, genocide, crimes against humanity, which is to say it's a very high bar. So in order to bring an Alien Tort Statute case, you have to be not from the US. You have to have experienced a very egregious human rights abuse, so torture, extrajudicial killing, crimes against humanity, or genocide. And the limitations, the sort of the hoops you have to jump through to bring one of these claims have increased in the last few years pretty significantly, and most significantly through the Kyoble case that Charles mentioned, in which he was a plaintiff. So the Kyoble case, prior to filing that case, another group of Ogoni plaintiffs filed WIWA versus Royal Dutch Petroleum. This is basically factually identical to Kyoble versus Royal Dutch Petroleum. And the WIWA case, interestingly, settled for $15.5 million in 2009. So the claims in that case were related to the murder of the Ogoni Nine rather than this broader human rights violation related to the repeated thousands of oil spills that have happened over the last 50 years in the Ogoni lands. So that case, because it was brought by survivors of the victims of the Ogoni Nine situation, that the $15.5 million settlement they got just went to that specific small group of plaintiffs. So it didn't remedy the broader harm. It didn't even really begin to address any of the broader harm. But the fact that it settled suggests that at that time in 2009, the Alien Tort Statute, it was good law for this purpose, right? So you could bring a claim like this and succeed against a company for a transnational human rights abuse. Following the WIWA settlement, the Kyoble plaintiffs, including Charles and brother Anthony Kotewita, who we have worked with, and some other members of the Ogoni community living here in the United States, who, as Charles mentioned, at this time were US citizens. So they had fled the Ogoni lands, been resettled in the US, and become citizens, brought this additional case against Shell related to the killing of the Ogoni Nine. Now when this case made it to the Supreme Court, the outcome was surprising. I think many people in the community did expect there to be a potential limitation of the scope of the Alien Tort Statute, but the limitation was much greater than anyone had expected. So what the Supreme Court decided in that case was there's something called the presumption against extraterritoriality. And Dr. Umlas raised extraterritoriality earlier. This presumption is that if the legislature passes a law and it doesn't say that that law should apply outside of the United States or outside of the territorial jurisdiction of this country, then it is extraterritorial and does not apply. So here they decided that because the Alien Tort Statute did not make totally clear that it was meant to apply outside of the US, even though the Supreme Court had previously found that it was probably used for piracy and crimes on the high seas, they decided here that it could not be applied extraterritorially, and that means that for any Alien Tort Statute litigant, you will not be able to bring that case in the US if the underlying crimes occurred outside of the US, and here's the caveat, unless it touches and concerns the United States with sufficient force to displace the presumption against extraterritoriality. So if it had sufficient connection to the US, maybe it would work. The lower courts have interpreted that to basically throw out just the vast majority of Alien Tort Statute cases that have been brought. So that's a great limitation to this case. The Alien Tort Statute was further limited just this year in a case called Jesner v. Arab Bank, in which the Supreme Court determined that if the defendant is a foreign corporation, that there's no liability. That was a very problematic decision that had reasoning that I would say would apply equally to domestic corporations, meaning that you potentially could not bring a U.S. company into U.S. court to hold them accountable for a human rights violation, even if they decided to do it in the United States, which is to say it would touch and concern the U.S. sufficiently to address that extraterritoriality problem. So this is a huge loss for the ability to employ international human rights law in U.S. courts. One other statute that has been used for this is the Torture Victim Protection Act. That statute was limited in 2012 by the Supreme Court to not apply to corporations. So U.S. courts at this point are a very difficult forum for international human rights cases. So the Ogoni have taken their case elsewhere. So let's see what happens as they've traveled around the world trying to pursue these claims. So the cases in the United Kingdom have gone better, but not great. So there was a very successful case on behalf of the Bodo and Bile communities, who are villages in the Ogoni lands that experienced two very serious large oil spills in 2008 and 2009. So thinking through our list here of our three factors, who is the community being represented here? It's the Bodo and Bile communities. So it is a big group of individuals. This is 15,000 plaintiffs, but in the Ogoni lands are around a little bit smaller than New York City in land space, and they have about 1 million people. There's different numbers there, but let's say about 1 million people. So 15,000 of them, which is to say a good size hunk, but not representative, brought this case, and they achieved a settlement of 55 million pounds along with a remediation plan. And while there have been some difficulties in implementing the remediation plan that I won't go into here, this is a huge success. One facet of this that I think is really important is that originally the case was filed against, and here we're talking about our third factor, who is the defendant, against both the parent company, Royal Dutch Shell, and the subsidiary in Nigeria. The parent company, in exchange for being let out of the case, the subsidiary accepted personal jurisdiction over that subsidiary in the UK. So that's a really important facet of this. So they got it against the subsidiary and not the parent corporation. The next case that was filed on behalf of 45,000 Ogale farmers, similar situation, except that instead of it being based around two specific oil spills, they based it on many of the issues raised in the United Nations Environmental Program report that Charles referenced earlier, that looked at just the extraordinary level of contamination of the land. So in that sense, the harms were much more generalized that they attempted to address. And the other thing that's special about this, when you look at that third issue, who is the defendant, is they didn't want to let the parent company out. They wanted the parent company to be involved in this case all the way through. And in the end, that case was dismissed because the court determined that the parent company did not owe a duty of care to this particular group of Ogale farmers. So this is a big issue, the duty of care. There's a lot of, if you want to look this up, expanded duty of care is something that there has been some law journal articles written about and some discussion of. The idea that in this type of transnational corporate abuse, it is so difficult to get common tort principles to apply and to work in this environment where the abuse is in one country, the company's in another country, there's a flow of goods and services across the globe. How do you extend the duty of care from the responsible parties all the way down to those who were harmed? And so there's a lot of discussion about how that could be done. So essentially what the court here said in the UK was that the duty of care does not extend all the way down. And I think that raises another problem. So in addition to these, so while the UK cases have had some success, there's 2 additional cases that have been filed in the Netherlands, and both of those cases are still pending. In those cases, Ogoni members of the Uruma, Goi, and Ikot Ada Odu, I'm sorry about that, communities filed suit in the Netherlands that were based again on a specific oil spill. And then in addition, Esther Kiobel, who is one of the plaintiffs in the Kiobel litigation in the United States, whose husband was killed, filed suit there for the murder of her husband. So you have 2 very different types of claims with different types of groups of plaintiffs that filed in the Netherlands, and those cases are pending. So we'll see what possibilities exist there. I know that I am running a little short on time. I'm almost done. So the last country where the Ogoni have brought claims is in Nigeria. Now, hundreds of cases have been filed in Nigeria against Shell over the last 25 years. I'm not going to get into details on these cases for a lot of reasons, but I will say that plaintiffs have not had very much success. So the fact that you see the Ogoni all over the world trying to seek justice is one indication that they were not able to find the remedies that they sought in their home country. There are many reasons for this. It includes the way that statutes are written, but that does not appear to be the main issue here. The position taken by many Ogoni and many other advocates, Amnesty International and others, have taken the position that Shell's notorious corruption is really the reason for this. So as you may know, there have been 2 Foreign Corrupt Practices Act cases instituted by the US government against Shell related to bribery in Nigeria. Nigeria is, there is a serious corruption problem there generally. I think that there is significant evidence that Shell has dramatically exacerbated it. Shell has even bragged that it has put one of their people in every agency in the Nigerian government as a mole. So one of the Ogoni kings who was behind some of these cases in the UK and the Netherlands has said about this, and this really reflects things that Charles said to us today. He said, this is King Emere Okpabi, said, "You can never defeat Shell in a Nigerian court. A case can go on for very many years. You can hardly get a judgment against an oil company in Nigeria. Shell is Nigeria, and Nigeria is Shell." So insofar as the ideal situation would be that victims of human rights abuse would be able to go into their own local legal system in their own language, using laws that they're more familiar with, hiring attorneys that are from their own culture, potentially having access to mechanisms of justice that reflect their own cultural traditions. That would be ideal. That's not working in Nigeria, and it's not working in a lot of other countries in the world. So I just want to close by saying, again, just reiterating, I think that the way that the Ogoni case shows the types of remedies available across the globe is a real testament to what extraordinary activists and advocates the Ogoni have been. It also shows how difficult it is for victims of transnational corporate abuse to obtain remedy in our current global system. Right now, Corporate Accountability Lab, we formed in response really to the Kiobel case, to the way that access to remedy, while it was very difficult before, has really been shut down in meaningful ways. And so we're looking at ways to use other areas of law like patent law, contract law, international trade law to try to bring human rights claims in different form. And while it's still ideal to bring them as human rights claims, I think that's very important to uphold the international human rights system. Because we don't have the ability to do that right now, we're experimenting with different mechanisms to do that. So please feel free to check out our website and you can learn more about that. And then the last thing I'll say is that we have Brother Anthony Kote-Wita, who is one of the members of the Ogoni community that fled the Ogoni lands, as well as a psychologist and another attorney, and I have written a short paper that discusses a lot of the issues that I've talked about today. I see some of the questions here, which I will read and get to in just a minute, touch a little bit on case citations, etc. That will be in this report that we will be releasing in the next couple of weeks as a sort of accompaniment to this webinar. And with that, I will pass it back to Amilcar. Thank you.
Thank you very much, Charity, for your really interesting explanation of what are the challenges to bring justice in domestic court, also at the level of international jurisdictions. So we know this is quite challenging and there is not really one solution. However, I want to say that there are some questions that are arising now. So I would like to start with the question addressed to Elizabeth. Elizabeth, do you have access to the questions that you have been sent to you? Actually, the question is related to... Okay.
Yes, I do. I'm not sure that I quite understand the question, mandatory judicial or non-judicial framework that addresses multinational shell companies, which I assume means not shell, but companies that exist as shells of one another. So I'm not sure that I quite understand that question. Perhaps Charity understands what that is getting at. Is that the one that you're talking about, Amilcar?
Yeah, the question from Penelope, is there any mandatory judicial or non-judicial framework that addresses issues of multinational shell companies? As far as we know, there is no one legal framework for one company. Of course, there are general frameworks, but I don't know, Charity, you want to address or comment more? I think we can activate our videos.
I'm not sure if I totally understand the question. The only thing I will say is that insofar as we're talking about sort of the problem that shell companies raise in terms of liability shifting between different companies, they're called shell companies, much like, you can sort of shift them around and they're very secret in some ways. There are good legal reasons for shell companies. They're not totally indefensible as a structure. At least in US courts, in US jurisprudence, there are a lot of federal court cases that cast doubt on whether or not a shell company who is just a shell company should be able to totally shield a operating company or a parent company from liability. So I've seen it some in domestic legal systems, but in terms of a mandatory judicial or non-judicial framework that addresses that issue more broadly on a global scale, I don't believe so.
Okay, thank you. There is also another question from Alex regarding the issues of alternative dispute resolution. Do you have access to that question?
Yes. Well, I think, Charity, you might want to speak about ADR, but I wanted to just jump on one aspect of that question, the OECD process and, absent pressures. One thing that I didn't really get to say when talking about judicial and non-judicial mechanisms is that I said that it's important to have both together, and non-judicial mechanisms do provide a complement to legal paths. From what I understand, they tend to be more successful when you have a legal case that's already filed, or you have the threat of a legal case being filed. That sort of focuses the mind and may make something like alternative dispute resolution a more attractive possibility. However, there's been a lot of research on non-judicial mechanisms, the overuse of them, and it's certainly the case that for egregious human rights violations, such as we've seen in the Ogoniland case, oftentimes a non-judicial mechanism may not be appropriate. Certainly not as the only solution, and that's been shown in other extractive cases. In the Barrick Gold case in Papua New Guinea, which went through a company, an operational level grievance mechanism to deal with accusations of gang rape of women at a mine by the security forces of the company. And one of the conclusions that came out of a lot of the research was that it may not be appropriate at all to use certain non-judicial mechanisms for such egregious human rights violations. Maybe Charity, you might want to talk more about alternative dispute resolution or some of the other aspects in this question.
I will a little bit, though I want to kick this middle question to Charles. So, the issue generally, I think here is about how do we get companies to negotiate in good faith, regardless of what mechanism it's coming through. So even if you're in a settlement agreement or a settlement negotiation with a company, the reason that they're negotiating in good faith is because they're afraid of getting a judgment against them. I think that as a practical matter, and maybe this just sort of shows my worldview, but I think of this in terms of economics. Many of these companies view these types of harms as externalities. These are problems that they can push off on local governments to deal with. So you create a social problem and it creates poverty or it creates pollution. And you want then the host government's environmental organizations or environmental agencies to take care of it, or their welfare agencies to provide a living, standard for people who live there, despite the fact that it was the corporate activity that resulted in that. So I think that to get companies to internalize their externalities is really a question of economics. How expensive is this for them, and how expensive would it be for them to not do it? And so as we try to set up systems in which companies and victims groups can come together and negotiate in good faith. I'm not trying to say that there are no good or ethical actors inside of companies, though I think that there are some problematic incentives in corporate structures that make it difficult for companies to take the right decision if it's the more expensive decision. So for me, the question is, how do you make it so that it is too expensive to ignore these problems? But that's a little bit of a broader framing of it. Charles, I wanted to kick to you here. Alex asks, also, do communities such as the Ogoni have faith in negotiations with companies like Shell, given the poor track record of the multinationals they seek relief from? What do you think about that?
I would say quickly that my experience with Shell is that when they are caught red-handed, they don't want to admit, but they want some other corporate bodies, to negotiate for them. Like in the WeWork versus Shell, they quickly paid the 15.5 million. Mm-hmm. And, when the UNEP report came out, and found them in violation of the Ogoni environment, they didn't say anything. They didn't say we did it. All they did is, okay, this is a 1 million, use it and doing it. And again, they are ensuring that they have Shell staff on what else, how do I put it, on the bodies that will take care of, sitting on the corporate body that will take care of this remediation program. Why are they there? Because it's not like they're releasing all the money. They're releasing the money gradually, and they don't want to pay all, and they want to bring back some back to them. So that's what I said. So they're not good in any way at, I don't see any faith in negotiating with them. I believe that the court system, finding them really guilty and making them take full responsibility is the only remedy to, Shell and community relation.
Yeah. And there is another section also from the question relating to the OECD process, in particular the focal points. What's your position about this?
This question of, absent such pressures, how can multinationals be compelled to engage in good faith negotiations? Is that the part you're referring to, Amilcar? Yeah, I would say on that, I think there's a lot of ways to do it. I definitely strongly believe in the importance of communities organizing and publicly demanding of companies that they comply with human rights norms. And I think that's something that can be done by affected communities, by consumer communities, in consuming countries. That kind of activism is essential. Here at Cal, we are trying to compel them to engage in good faith negotiations through other types of legal strategies that would embroil them in litigation until they are forced to negotiate with companies. So we're looking at coming after them with contract law claims or intellectual property related claims, but fashioning those as human rights related claims. So that's a little bit of an unusual way to come at it. I recognize that. Though I think it's hard. It's very difficult. And I think what you'll find is that a lot of companies have not negotiated in good faith over many, many years, and people have been further harmed by the lack of remediation. So we need to use all of the tools at our disposal to get them to the table.
I would just jump in on that point, Charity. We were talking about different communities of pressure. I mentioned at the outset investors, and that is another leverage point that has increased, particularly with regard to human rights issues. There's been kind of a lag. Investor pressure has often been used in corporate governance cases, in environmental cases, and there's been a lag on human rights, but there's been more and more attention to, particularly in the wake of the guiding principles being endorsed, to this whole body of impacts that companies have on human rights. And so there's a consequent gaining of knowledge on the part of investors about the risks that their companies are exposed to when they are going around the world and having negative impacts on human rights. So although that's another somewhat indirect form of bringing pressure to bear on companies to make them engage in good faith negotiations, it's certainly a body of leverage that is it's ripe for being brought into this group of tools that we have. And as investors become better acquainted with their responsibilities under the guiding principles, because they have responsibilities as commercial entities, I think we may see some interesting things happening with the national contact points. There have been cases where investors have also brought pressure to bear on companies to bring them to the table with national contact points. So somewhat indirect, but I think there's some future there.
Great. So just to mention that, yes, all the information regarding the slides will be sent to all of you because all the session is recorded. And of course, I will ask the panelists to send the slides eventually to send you in a separate version all the information. And of course, we will try to provide some case summaries to you, in particular to Christopher. Yeah, there is another question to Charity regarding from Linde regarding criminal investigation in Nigeria. I think this is a question actually for Charles. Well, what can you say about it?
Yeah, I would give that to you. On criminal investigations of Shell in Nigeria?
When you say criminal investigation of Shell in Nigeria,
for
that's
their
difficult.
Environmental pollution.
Yeah, that's difficult because if you look at Nigeria, Shell has its own police. And in the police system, in different institutions in the country, you have them. So where would that go to? If, a government gets money from Shell to operate, the governmental functions. So how can that government actually send its judiciary against a company that takes care of them? It's really difficult. It cannot happen, and that's why we took them to court as soon as we settled down in the United States, believing that we'll get justice here. In Nigeria, I don't see any form of justice until we have, the different arms of government being independent of each other. But if the judiciary is there waiting on executive to give them, on how to handle things, and it's going to be difficult. You cannot investigate them. Police cannot even stop any shell worker on the street because they have their own police, taking them to oil fields, taking them, they're going to. So an authority of their own. They have shared camp that nobody can get to. They have shared residential area that only shared staff lives there. And they do all kinds of things. They commit all their crimes, and their crimes are legal in terms of Nigeria, in terms of the Nigerian system. Whatever Shell does is legal.
And maybe just to provide a sort of broader answer to the question, there's definitely in the advocacy community a push toward, for example, International Corporate Accountability Roundtable put out something called the Corporate Crimes Principles. Amnesty has called for criminal liability of Shell in Nigeria, in the UK, and the Netherlands. So there is certainly a push by advocates for more criminal liability of companies, and especially in this case, but it hasn't really materialized yet.
Yeah. So actually there is a question regarding actually the prevention of cases of violation of human rights. If large corporations like Shell can cover so much over developing countries and governments, would it be better to use law to intervene before corporations enter to a host country when they are negotiating the contract, something like that?
Yeah, that's a good question, and I would put that together with the one after it, which is please give examples of binding sources of law which require a corporation to conduct a human rights due diligence as a condition for operation in a foreign country, i.e. before they might have done the damage. And so I'm not a legal expert, but as far as I know, there isn't that kind of conditionality. The laws that I mentioned at the very end of my remarks that are now emerging around mandatory human rights due diligence are not conditions on companies before they can go overseas. They are supposed to apply to, I mean, in theory, they're supposed to apply to companies starting new operations, but it's not a conditionality, and it applies to ongoing operations as well. There's been a lot more attention to the concept of prevention in the last couple of years. I would say it was something that was in the background when the guiding principles were being created, and it's something that necessarily has started to come to the fore. Obviously, you would save a lot of, companies would save a lot of money, and we would save a lot of people from suffering if prevention were the main concept. But it's taken a long time for that to be put front and center.
Yeah, Charity?
And I would just add to that, I think that a lot of, because of the lack of effective public law on this point, so this idea of requiring due diligence before you go into a country, or really having binding due diligence norms, there are pieces of domestic. There has been a lot of advocacy efforts that have focused on using private law, so primarily contract law, to get companies to comply with these sorts of norms. So one example of this, there's an organization called Electronics Watch in Europe, and Electronics Watch has created contract conditions that public entities in Europe who are entering into contracts to buy computers and other types of electronics for their government operations, whether this is a public university or a city or a whole country, in those contracts with their contractors. So, with IBM or Dell, whoever they're contracting with to get their electronics, they include conditions that include human rights due diligence and other types of expectations. Now, if they fail to comply with that, well, you couldn't bring a case against them for, broadly for the violation. What you could do is you could bring a contract law claim against them. You could say that if Dell was producing these electronics in these computers in a place where people were being exposed to a chemical that was causing them, some sort of harm, that they would be able to bring that as a contract law violation. But that doesn't really provide a remedy to the harmed person. It provides a remedy to the public entity who contracted with Dell. This is just an example. Dell is not, I'm just throwing out an example here, but, so that creates kind of a private law mechanism because the public law ones are lacking. And so I think that increasingly I have seen more and more of these popping up in different industries to try to deal with some of this. But again, it's very patchy.
Yeah, thank you. There is another, actually, this is a comment. Yeah, the reason why some questions are not appearing on the chat section is because some of them decide to send the question privately. So it's not publicly, because actually you can choose. You want to answer the question to all of you, to the panelists and participants, or only the participants. And that's why some questions are not appearing. We are not actually quoting or framing the question exactly. We are trying to respond to all of them. So there is another question from Ali regarding, is there a role for criminal law to play in targeting corporations, especially in European countries that have universal jurisdiction? Before actually giving the floor to Charity or to Elizabeth, just to remind, there is just some weeks ago, there was a case that actually goes into the sense of your questions, because it's a French company called Lafarge, who was actually charged for human rights violations for their actions in Syria, because during the war that we all know, they were actually giving or encouraging through money to belligerents in order to protect the sites where they operate. So actually in France, they were actually charged of that, and many of the main investors are actually sued into the French courts. So actually this is a new approach, but it's a very, I would say, militant way of doing by the French jurisdiction. It's under development, of course, but maybe this is we'll be very interested to read and to learn more about the case in France regarding the Lafarge construction firm. So Charity or Elizabeth.
Yeah, I think the Lafarge case is really interesting, and as far as I know, that's a first in terms of a French multinational being indicted for complicity in crimes against humanity for, I think it was its subsidiary in Syria. I don't know, Charity, if you have anything to add to that question of the role for criminal law. I mean, obviously it depends on political will of governments as well, and there's been a lot of good work on this. There's a document called The Third Pillar, and ICAR, which Charity has mentioned, and Amnesty have done a lot of good work, publicly available reports on criminal liability.
I mean, I guess I would just add that I think that that's right, that we can continue to put pressure on governments. And I think that's a great role for our grassroots organizations to try to push their own governments, because they're obviously the constituents who vote for their representatives to push their governments to take more action against companies. But short of that, it's difficult to convince governments to act. And I know that certainly in the United States, because I think we all know we have a bit of a situation with campaign contributions by companies, et cetera, corporate accountability legislation and taking strong actions against companies has been a little bit difficult to manage even here, which is to say that getting that to happen in Nigeria would be perhaps even more difficult. So I think that criminal liability hopefully is a part of a future of corporate accountability that we have, but it might be a long road before it becomes a main sort of consistent strategy.
Yeah, there is no really, for the moment, examples of this. Maybe the one who may be arising is the one from Lafarge, but yes, this is as I just said, under development. We have to still watching what's going on and then to extend the research on the ground. But yes, I think we have to use any tool available to us. And there is a final comment or question, I'm not sure, from, I think it was Sabrina. Do you have access to that too? Using private law. Using private law, they might also circumvent local government corruption issues or not, if through contract law claim the public entity of host country will get remedy, then the host government will be less incentivized to make money from Shell.
Yeah, I think that's exactly right. I mean, I think that it does really change the incentives if public entities are going after their own contractors for those kinds of human rights abuses. It means that, you know, that kind of setup where you have a big institutional buyer, so someone who's consuming a lot of the product, not just the individual consumer, but somebody at such a level who's purchasing whatever the product is at a large scale. They have a lot of power in this system, right? It's an economic power that they have. But because they can embed this kind of information in their contracts, they can turn that economic power into a legal power. I think one difficulty is that often, and this has been the case with Electronics Watch, but I think this is true with a lot of these systems, where you have this kind of institutional buyer exercising control through a contract and embedding labor norms or other types of human rights related conditions in a contract, is that the two parties to the contract are in a business relationship, right? So if you're a big company, if you're a university, let's say, and you are contracting out all of the production of your university clothing to some large apparel company, let's say it's Nike. So you have this contract with Nike over years and years and years, where they're producing all of your university branded apparel. You're a huge institutional buyer. You can force Nike to put things like labor provisions in your contract, maybe environmental protection provisions in your contract. The question is, when it comes time to enforce, when a violation happens at one of those factories or in Nike's operations while producing your stuff, are you going to enforce? Are you actually going to sue your business partner over violation of the labor provision? You probably would if they didn't deliver the product on time, or it wasn't to specifications, or they caused you an economic impact. But are you as an institutional buyer actually going to take the steps to enforce? And that has been a real problem in a lot of these systems. And so in Electronics Watch, you know, if the government of Sweden needs to sue to enforce their contract conditions, asking them to enter the contract is step one, but getting them to actually enforce it is step two, and that's been a real challenge. So I think that that's right, that this does provide a really important workaround to the lack of effective mechanisms in other fora, but it's not perfect either right now, but there's potential there too.
Yeah. Thank you very much, Charity. Actually, this is just a comment to explore more information regarding corporate responsibility. This is one actually from Oxfam's contract disclosure project. I think, yeah, the most survey contract disclosure which companies and contract participants available online. Yeah, of course, we will analyze this tool available from Oxfam. And yeah, so eventually, if you want to also to share more information about it, you can also comment about that. There's no problem. Just to say that if you wish to know more about Corporate Accountability Lab, I just added the website of the organization, which is legaldesign.org, on the chat section. And also, if you wish more to access more information about the Ankawa International Organization, you have also the website over there. If you have more comments, just let us know. Otherwise, we'll be closing the webinar section. I just want to remember that all this session will be recorded, so you will receive a follow-up mail tomorrow with the information regarding this session. If you wish to know more about the activities, in particular the coming legal activities for Ogoniland, let us know. Also, I will send you a mail to when you can contact directly the organization. And this will give you the opportunity to interact with the group, preparing the case. Also, because I know that some people are also members of another human rights organizations, you can also contact us eventually to share efforts to coordinate actions. I think there is no more questions, so yeah, so there is no more questions. So thank you very much, Charity, Elizabeth, Charles, to all of you people for participating, and let's keep in touch regarding this exciting and challenging issue of access to remedy in cases of human rights violations committed by multinationals. Thank you very much, and that's all. And now the webinar just ended. Thank you very much.
Thank you.
Thank you.
Thank you.